Hey, estate planning attorney Paul Rabelais here, and in this video we're going to talk about whether you should sign all your original estate planning legal documents in blue ink, black ink, or some other color ink. So over the last roughly 30 years of being an estate planning lawyer, I've had to answer a number of questions, hundreds if not thousands of times. So constantly, every week, every day, just about, I'm answering questions like, Paul, should I have a will or a trust? Or Paul, how do I keep my estate in the bloodlines? Or Paul, what are the tax consequences of me arranging my estate in the way that we've discussed? Or Paul, can I name two co-executors instead of naming just one? Or I'm asked, Paul, does what we've talked about, does that make sure my family avoids probate? Or how do we protect our assets, Paul, in case we go into a nursing home? Or Paul, will my bank account be frozen when I pass away? So those are just a sample of some of the dozens of questions that I've probably answered those questions 1,000 times or more. But there's one question that I've asked even more than all of those questions. It's, Paul, we've got all this paperwork in front of us. We're ready to sign. Do we sign in blue ink or do we sign in black ink? And I know that's a highly technical legal question, but I know this is a little bit different video, but you know what? I get asked the question so much, I thought I'd lay it all out in a video. So I'll start out by saying there is no law, no statute, no regulation which states that estate planning legal documents must be signed in a certain color. And I guess you could probably use a pink Crayola if you were so inclined to do it. But what should you do? And I'll say, it seemed like years ago, a lot of people would come into the office and say, they'd be ready to sign. They'd pull out their black pen and say something like, well, Paul, when I was in the military, we always signed everything in black. And I guess it was just entrenched in the military that you sign all paperwork in black ink. So they would be, surprised when I say, whoa, hold on there, Nellie. Let's maybe consider using a different color ink. And so we'd have to get over that. But here's why we typically suggest that all of our clients sign all of their estate planning legal documents with, voila, a blue pen. All right, so some original estate planning legal documents get recorded at the courthouse. So for example, when you pass away, if you had a will, the courthouse wants the original will and the original only filed at the courthouse. If you sign a power of attorney and your agent needs to use that, many third parties require that your original power of attorney get recorded at the courthouse, and then the courthouse issues certified copies that go to those third parties who will honor that certified copy. Sometimes people, and as part of the estate planning process, they transfer real estate to or from individuals or trusts, and all of those original transfer documents get recorded at the courthouse. Courthouse always wants the original. And while it's not necessarily a slam dunk, it's easier to determine which document is an original when the original is signed in blue ink, because photocopies of original legal documents are often made on black and white copiers. And when you photocopy a legal document where the person signed in blue ink, that photocopy, which is made on a black and white printer, on the photocopy, on that signature line, the signature is going to appear in black. So it's pretty easy. Hey, this one's got the blue signature, this one's got the black signature, this is the original, this is a photocopy, and that helps us determine which one is easier. Now, if that original, which was signed in blue ink, is copied on a color photocopier, sometimes it, got to look a little closer to see which one's the original and which one's a copy. And sometimes we can't tell. And when we can't tell, sometimes we got to go to plan B to determine which one's the original. And plan B is often, well, let's look at where the notary notarized the document, and see if that notary seal, is raised on the document. Because sometimes the notary, they do their stamp on the document, and it raises the paper, and so it's pretty easy to determine. You can feel on it, oh, this is the one, this is the original that the notary sealed. I can feel it versus just a photocopy of one which isn't raised. So that's another way to determine which one is the original. Now, even more important, I mentioned earlier on the last will and testament, because we have a rule, and I don't know that I agree with it, but our rule in most states is if the original cannot be produced after the person who signed the original died, then there's this presumption that the person who signed the will destroyed it with the intent to revoke it. So that makes it even more important that the original will be produced after somebody dies, which is often 20 or 30 years after it's signed. So real important there that we determine which one's the original. I'll also mention sometimes, it comes time to sign, and it's real important for some reason for one of the people signing the documents. It's real important, they pull out their own pen and say, this is my pen. I sign everything with this pen. Either they just like their pen, or for some sentimental reason, they want to use their pen, and their pen is a black pen. So I'm not going to stop them from signing their estate planning legal documents with their black pen, because quite frankly, if the notary and the witnesses sign in blue ink, we're good. So even if they signed in black and the photocopy of their signature is in black, and on the original it's black, so we're not sure if it's an original or photocopy, the notary and the witnesses signed in blue. So as long as really as somebody signs in blue, it helps us determine which document is an original and which one is a photocopy. Now I will tell you, last several years, I know in our office we try to be as paperless as we can. We give the original documents to the client, but after they sign them and before we give them their documents, we scan. And so scanning is now really, really common. And when you scan in a document where the person signed in blue ink, and then you pull up that PDF later on your computer screen, well, on your computer screen, it's going to show the blue ink. But when you print it, maybe on a black and white printer, it comes out black and white. So we got to get through all those things as well. Probably, though, the most important kind of determination on this blue or not blue color is right there where you're looking at. There's a gray thumbs up button. Real important, and a favor to me, if you would turn that gray like button into a blue like button, that tells YouTube, hey, show Paul's videos to more people. And then if you want to sign your documents in red, that's fine. But if you do that, also make sure you hit the red subscribe button and the notification bell. That way you won't miss anything as I keep cranking out these estate planning videos on a daily basis. Keep you more informed. You're able to make better decisions and have peace of mind that you've done what you needed to do to protect your family. Bottom line, blue, black. Let's go with blue on all your estate planning legal documents. It may prevent some confusion later. We'll see you next time.